Welcome again, everyone. I hope you had a hearty lunch break. I would again like to extend a warm welcome to all the guests to the International Virtual Conference on the new facets of consumer protection, challenges and way forward on behalf of the Chair for Consumer Law and Practice NLSIU and the Ministry of Consumer Affairs. One cannot underscore enough the importance of today's conference. It aims to provide profound insights into the various facets of consumer law. This parallel session particularly is pivoted on the theme of consumer protection from fake reviews on e-commerce portals and other dark patterns. For any new listeners here, I would quickly like to introduce our two chairpersons who would be the judges for today's session. Our first chairperson is Dr. Anita A. Patil. She has completed her bachelor's and master's in law with specialization in business and trade law. She was awarded with 2 gold medals for securing the first rank in specialization of business and trade laws, Masters of Law 2012 at the Karnataka University. She has qualified UGC NET JRF Fellowship Award in the year 2012. She had joined the chair on consumer law and practice at the National Law School, Bangalore in July 2012. She has successfully completed her PhD research degree on the research topic, a critical study of legal framework to control misleading advertisements in India, with special reference to food, drugs, and cosmetics from National Law School, Bangalore in 2018. She is also an accredited mediator by completing 40 hours of training module in negotiation and mediation at the Indian Institute of Arbitration and Mediation. She has actively contributed in the policy making on the Consumer Protection Act 2019 to the Ministry of Consumer Affairs of the Government of India, along with the chair on consumer law and practice. She has also presented research papers at national and international conferences and has various national and international published articles for her credits. Our second chairperson for today is Mr. Avantik Tamta. Avantik Tamta is an alumnus of the West Bengal National University of Juridical Sciences. He was conferred the University Gold Medal for International Environmental Law and Intellectual Property Laws for the graduating batch of 2017. Having been recruited by LNL Partners, then Luthra and Luthra Partners, Avantik worked with Tier 1 firm in their Mumbai office as an associate in the banking and finance team. He gained significant experience as a transactional corporate lawyer before deciding to move to the Calcutta High Court in order to take up responsibility as a research associate to Honorable Justice Dibankar Datta. Apart from his interest in the realm of IPR, he also carries a passion for the study of human rights law. He is a member of the NUJS Center for Law, Literature and Pop Culture, and also the NUJS Center for IP and Technology Laws. I would again like to take this opportunity to thank our keynote speakers. Our keynote speakers, as well as the chief guest in the inaugural session today, have highlighted the importance of online reviews in today's day and age. We all rely on them while shopping from e-commerce websites. However, they have also pointed out the deep dangers of fake reviews. Professor Tiwari, our first keynote speaker for today, lucidly highlighted his study on fake reviews, where he utilized more ground-level resources to understand the impact of online reviews, the level of consumer awareness, and some possible suggestions for the way forward. Professor Dan's focus, on the other hand, was on the Chinese perspective of consumer laws, mediation and ODR as forms of dispute resolution, and other kinds of laws complementing it. And this, in my opinion, was extremely insightful. I once again thank them both for their wise words. Moving on to our schedule for today, we have 4 presentations on this session's theme. They are, first by Ms. Ruth Wefei, an avenue to combat fake reviews on e-commerce platforms vis-a-vis consumer rights. Second by Mr. Abhinay Ramesh and Mr. Karthik KP, trusting a review, tricky issues in consumer protection. Third by Mr. Pratyanik Chakrabarti and Dr. Prantik Chakrabarti on unfair suggestion, an empirical and doctrinal study of recommended algorithms used by e-commerce entity. And fourth by Ms. Prasanna B, trap of dark pattern to the middle class versus trap of digital learning to the poor, the silent coercive tools to exploit consumer choice. Now, I'll lay down some basic housekeeping rules. I would request the presenters to finish their presentations in ideally 13 minutes, 13 minutes. In any case, since we plan to begin the valedictory session on time, it should not exceed 15 minutes. From now on, Ashish will be keeping time for every presentation, and he will signal on the chat box when 10 minutes are left, when 5 minutes are left, when 2 minutes are left, and when it is time to wrap up the presentation. If the audience has any questions in between, please direct them on chat to Ashish personally, and he will be raising them when all 4 presentations are over. Further, a round of questions and answers, as well as feedback on the presentation from the end of the judges, will take place at the end. I wish everyone the best of luck, and I pass over the mic to Ashish to invite the first presenter. Thank you.
Thank you, Kriti. Now I may invite Ruth Raife if they're available to present their topic.
Yes, I'm available.
Certainly. Thank you.
All right. So do I need to turn on my video? I'm in camera.
Would be great if possible, if there's no interruption.
Also, can I share my PPT?
Right. Is this not shareable at the moment? I'll just fix it 1 second.
You can share. Is the option to share screen enabled for you?
Yeah, just give me a minute. Yeah. Is my screen visible?
Yes, it is.
Okay. Let me try to turn on my video, my camera. I think it's something, there's a glitch, I guess. All right. Well, due to time constraint, I'm not going to hit around the bushes. I'll just went straight to the point. So this is my topic, which is an avenue to combat fake reviews on e-commerce platform vis-a-vis consumer rights. Now, what all I'll be cover is, first of all, I will just introduce a bit of what e-commerce is. Of course, we all must be aware of it already. And then I'll discuss about this while making a purchasing decisions, what all are the factors that affect our decisions making power. Then I'll move on to how to spot a fake review. Of course, this spotting a fake review would not be me coming up with an idea, but this would be based on reliable sources, how they try to make aware the consumers how to spot a fake review. And then I'll go on to implications of fake reviews, and then come to conclusions and what are the suggested avenues. Now, talking of how this fake review is of great concern now. So what happened is in today's world, we know that we have reached digital world with the advancements of internet and advancement of digital world. Things has changed. The dimensions of the earth, the world has changed, like how we do shopping, and then how we conveniently sit at home. And despite the COVID hit badly the world, despite that, we could still rely on shopping online, and then we still get what we wanted. Yes. So as much as our life is very convenient, there is also a great concerns, the implications and the repercussions, how internet has made our life convenient. As much as it made it convenient, there is also a repercussions to everything. So here the concern is the fake review, because since digital world has limited our chance of evaluating physically the product which we would want to avail online, that chance has been limited by online platform. So we basically rely on the feedback which is being posted by already product user. So now the concern is when the review are not genuine, that is of great concern. So when we rely on those review and happen to purchase things which are not of what they seems to be, so that is a great concern, because it affected our consumer rights. So now talking of a bit of e-commerce. We all know that e-commerce, as per the research earlier, as per the US Census Bureau, 5% of all retail purchases in 2011 were made online. And after the pandemic hit the world in 2020, it had risen to more than 16% of retail sales through online. So that's how we basically rely more online purchasing. Now, talking of e-commerce, for a better understanding, there are various types of e-commerce. We have B2B and we have B2C, C2C, C2B. Now, talking of concern of e-commerce here, we're not concerned with consumers to business to administrations, where some let's say technology data providers provides a service to the government in protecting government services and everything. And then the other thing is that consumers to administrations, like for example we have let's say tax filing portal. So these are some basic examples of e-commerce when we talk of business to administration and consumers to administrations. But we do not face any such problem when it comes to this business model, which is business to administration and consumers to administration. But the concern is when the other types of e-commerce, which is business to business and business to consumers or consumers to consumers. So example of all these kind of business models are, we have Nykaa, because Nykaa is not just a retail seller, they also provide platforms to other customers to reach out to other customer also, because some product, instead of investing so much on having their own building or let's say business headquarter, sitting at home, they could sell their product also. Likewise, Amazon is also providing such kind of products. So this kind of business models are known as consumer to consumers, or business to consumers. So now the concern is that in B2B or B2C or C2C or C2B, there's more chances of coming across or encountering various fake review. So because B to A and C to A, that is government involvement is there, and then we don't really rely on customer feedback to avail the service or to convey the information to the government. So now that is what a basic idea of how e-commerce, various e-commerce work. And then coming to now when we actually have to purchase product, these are various factors from whom we rely while making our purchasing decisions. So when we talk of online user feedback, there is a difference between online user feedbacks and online review again. And to understand the mode of combating fake review, we need to understand the difference between these three set of factors. One is online user feedback. Now, what exactly is online user feedback? These are the feedback, like for example, after we avail the service of, let's say Amazon, you would purchase the product from any other businesses, but then at the end of the day, after you avail the product, you will get a feedback from feedback form from the Amazon site only. So that is user feedback. It is not product feedback. So that is called user feedback. It's different from online review. Now talking of online review, this is something which is available. Now talking of user feedback, it's not available publicly. Whatever feedback you give to the site, they will not publicize it. So basically they're collecting those data for them to evaluate or analyze and accordingly to work on it, if there's any flaws, and to improve their service. So that user feedback never really impact our decision making, but it is the online review, because online review is something which is available on the website, and then relying on those review, we make our decision making power. And then after that, talking of influencer, these days we have a social media world, we have various kind of influencer. Now how these influencers also impact our purchasing decisions. So talking of influencer, there are various kind of influencer. There are like mega influencer is there, there's macro, we have micro, and we have nano influencer. Talking of mega and macro, these influencers are very attached to their followers. Like now the question is, what kind of category influencers comes within the ambit of mega and macro? Basically, these are the influencer, for example, who have more than 1 million followers. Usually they are big celebrities. And macro also likewise, there are those influencers who has a followers of more than 40,000 to 1 million, but basically they are of TV smaller star, let's say. But these people, they will refrain from promoting any product. So whatever product they promote through their social media account, they know that the impact is going to be very grave. So therefore they refrain from product promoting any product which is not genuine enough, or which they felt, okay, it's not right to do so. So this mega and macro influencer also somehow they influence the purchasing power, but in a positive way, because as I say, they refrain from promoting something which is not genuine according to them. So now talking of micro and nano influencer, they are the smaller influencer who basically want to work for money. So they are those influencers who are ready to do anything, any sort of thing, as long as it brings them money. So this kind of influencer also influence our purchasing decision making power. But the point is, as long as the review of the product is genuine, that is not the concern. But the moment the review are fake, that is of great concern. Now, before we get into the implications, let's understand what is actually a fake review. So this fake review is being defined by Joy and three authors. As written here, I mean 4 authors. So according to them, I find this review is the app review. It gives all like clarity as to what exactly is fake review. These definitions given by these 4 authors, it's like they literally clarify what exactly is fake review. So according to them, when we say fake review, they name it opinion spam, they name it fictitious, or descriptions, or descriptions of a product in order to with an intention to deceive, or they call it a fictitious descriptions of product. So this is one of the best example I would come across talking of the definition of fake review without stretching much. Now talking of spotting fake review, before I discuss the implication of fake review, spotting of fake review, this is something I find it very interesting. I come across this based on my research, and this spotting of fake review is given by a company called Reputations, which is B2B, that means business to business, online. Basically their objective is online reputations management and customer experience management company. So basically their concern is customer interest. Now the CEO of this company laid down how to spot a fake review, considering the interest of especially commoner who have a very limited knowledge about how technology works, and we may not who will not have an access to like let's say hi-fi software in order to spot fake reviews. So for commoner like us, this is the best let's say point how to spot a fake review. So first is verifying a date, and second is specific words usually used by the fake reviewer, and then scene setting it, and then examine the profile. So this is a various way how to spot a fake review. Now talking of verifying a date, it says that based on the research, it is found that some company basically used to hire people or some other third party agent to just engage them for writing fake review of their product, who actually or who have not actually used the product. So for those people, when what happened is that the mistake they usually commit is that the review date is much ahead than the date of the launching of the product. So that is how we can somehow verify the date of like through verifying the date of the review, we can spot that it is, we can have an idea that this review is not genuine. And talking of specific words, since they used to write a review in bulk, so what happened is that they happen to write things. One thing they use usually a profile, or they don't, since they're just creating a profile to write a review. So at times they just use random alphabetic, or they just use random numbers, and then the other thing is that specific words, right, they tend to make more mistake, like verbs mistake or me, I, all these things. So and then in order to convince that the customer should feel that this is a genuine review, they tend to stress so much by describing the scene, like person describing so much, describing the place so much. This is usually it is very much common in hospitality sector, like, or let's say hotel sector, I'll put it that way. So this is how we can spot fake review. Now, talking of implications of fake review, before we get into the implication of fake review, we like coming to the Indian aspect, who actually are the consumers? To understand that, and to cut it short, I'll just directly point out Section 2, Clause 7 of Consumer Protection Act. As per that definitions, consumers are categorized into two. One is a consumer who purchases good, and the second one is consumer who hires services for considerations. So these are who the consumers should necessarily fall under this category in order to avail any kind of protections under the Consumer Protections Act. And talking of Consumer Protections Act 2009, it is created with the roots of consumers' rights, and then therefore the Section 2, subsection 9, trusted various rights. So which right exactly is being infringed by fake review? So we can point it out that Section 2, subsection 9, clause 2 is rights which is being infringed by fake review, because this particular sections envisage about right to informations regarding the quality, quantity, potency, purity, and standard and price of goods. So talking of fake review, they tend to pose the quality, which is the substandard quality, as a good quality. So they tend to describe the quality which is not genuine. So therefore, this particular right is being basically infringed by fake review. And then the problem is, had we get the chance to go to the shop and do the evaluations of the product physically, then this right would not have been infringed. But as I say, internet and digital world has limited our rights of evaluating the product. As much as it provides us conveniently to shop from home, it also limited this particular let's say opportunities of evaluating the product. So therefore, we just rely on the review posted on the site. So when we rely on the review posted on the site, as I say, when the quality is not as it is, how it's described, so therefore, this particular sections, which is Section 2(9), clause 2, has been infringed. Now, talking of implications, does fake review only, let's say, adversely affect the rights of the consumers only, or does it in fact affect the right interests of companies as well? So to know that, based on my research, I have found and that fake review did not just affect consumer rights, but also it is being harmful for other competitor company also, because other competitor company tend to lose out their sale they may have made otherwise, had it not for the fake review, because it's like a way to eliminate the competitor in the market. But as much as it try to eliminate the competitor in the market, it also has a repercussions for those companies who resorted to fake review. Reason being, these days, based on the research carried out by Bazaar Voice, so this Bazaar Voice is a technology company based in Texas. So they have conducted a survey in 2020. So it's a very, I would say, interesting survey. Basically, they conduct these surveys worldwide on online customer. So as far as their survey report was concerned, it says that 54% of online consumer worldwide will not purchase if there's a slightest chance of doubtful review or fake review on any website. So now talking of, I don't know whether it's right to quote this as an example. Let's see Snapdeal. It was also e-commerce. Now, why do you think Snapdeal could not sustain in the market? The main reason is many people stop trusting the site, because mostly when you avail product from Snapdeal, you did not really receive any genuine products. So Snapdeal may have rely on resorting to fake review or engaging people to write fake review by paying them or engaging third party. We don't know the truth, but this is my assumption. So I think because nobody would want to waste their time writing fake review on Snapdeal site unless they're being paid for it. So that means if Snapdeal was really engaging somebody to write fake review of their product on their site, then what is the repercussions? People stop buying, people stop using that site. So now what is, in the long run, what happened? Eventually, they are about to be eliminated from the market. So that shows that fake review did not just infringe the right of consumer as much as it infringes the right of the consumer. It also is deterrent for the companies, be it the competitor's company or be it the company who resorted to the fake review. So this is the implication. Now, I would like to conclude by saying that from all the research, whatever I have done, I could find that fake review, as I already just explained, that it is not just the consumer's concern now, but it is a great concern for businesses also. Therefore, to mitigate this fake review, both sides has to come forward, and then there should be a joint force to fight back this fake review. Now, coming to what could be the probable avenues to combat this fake review jointly. Talking of some giant companies like Amazon, in 2020, UK Competitions and Market Authority, which is like a watchdog, they also conduct inquiry into several websites of those this kind of e-commerce, and then they discovered that some business were purchasing or receiving or pay third agency to create a fictitious narrative for their goods and services. So that is based on the CMA, that means Competitions and Market Authority report. So now, then after that report, it was believed that, or it's not believed, it's based on the report that Amazon has eliminated around 20,000 of fake review from their site, and they also claim that they have used various software to detect fake review. But the question is, like, who would invest their time writing fake review on their website unless they engage first? So now, at the same time, they also claim that we also working on it to eliminate or to mitigate this fake review.
Can we request
So,
you to wrap up quickly? Yes. Because you've already gone over time. So maybe take 30 seconds to wrap up.
Okay, cool. Thank you. All right. So we know that companies' interest is also affected, and then consumer interest is also affected. So now the suggested avenue could be to establish a watchdog explicitly who will entertain consumer complaints, and then why not have a very convenient, explicit online portal so that if anyone, be it the company or be it any consumers, like happen to come across, then why not just have that portals where we could just post it or like inform the concerned authority. And like we have a corporate governance requirement, disclosure requirement these days in companies, likewise you also can have a framework for disclosure requirement. And then finally, which I think it would be best to have a imposing of hefty fine. So that's all. Thank you.
For the presentation. Because of the paucity of time, we'll just be moving on to the next presenters, Abhinay, Ramesh, and Karthik KB. And before you may start your presentation, I would just like to remind again, the 30-minute time limit has been provided. Please do not go ahead too far ahead from it and try to stick within the time limit. Thank you.
Am I audible? Yes.
You are, Karthik, go ahead.
Very good afternoon to the one and all present here. Myself, Karthik KP, a student, fourth year law student studying in the School of Law, Shastra, deemed to be university, and Miss Abhinaya Ramesh, assistant professor at School of Law, Shastra, deemed to be university, here to present our findings and analysis on the topic trusting the review, tricky issues in consumer protection. Our major perceptions, the e-commerce websites are here that they are not able to rank the reviews. What is a review? A review is basically an opinionated statement on the impact which a consumer or an organization has received because of usage of the product. It may be by their relative or any sort of manner. The e-commerce websites are confronting difficulties including ranking of such search results, identification of contractual obligations, online rating, and review systems. The research questions which we have posted here is that what is the perception of the consumers on the e-commerce reviews and how it affects their purchasing decisions. This was an empirical approach done by myself and Ms. Abhinaya Ramesh to understand how consumers are dealing with these reviews in the e-commerce website. And secondly, we had done a doctrinal approach where we had understood how European Union and US frameworks address the issue of this framework. And our empirical method was focused on these 4 themes: the star ratings and detailed reviews, profile and language used by the reviewer, positive and negative reviews, and trustability and practice of reviews. I'll be moving on with my doctrinal approach on how does United States of America and European Union address the framework of the issue of fake reviews. Firstly, there are fake reviews are affecting fair competition by creating misleading advertisements which may impact the purchasing decision of a consumer. The European Union states that fairness in advertising is mandatory provided that such advertisements are not in violation of an economic interest of a consumer. And Article 4 of Misleading and Comparative Directive, which states that comparative advertising is permitted if the trademark is not affecting the discredit or denigrate of a trademark or trade name, or does not take unfair advantage of a reputation of a trademark, or does not present goods or services as an imitation wearing the trademark. Whereas in United States of America, Section 43A of Lanham Act prohibits competitors who make false and deceptive statements even about their own products, which violates the fairness of advertising. The Federal Trade Commission Act also empowers the Federal Trade Commission which is an independent organization, to investigate and prosecute any organization which is in violation and also participates in unfair competition. Moving on, who is liable for posting of fake reviews in e-commerce websites? Both European Union and United States of America unanimously agree in one thing, that the internet service providers or the website hosts, in this particular case, the e-commerce websites, are not liable. In the European Union, the Electronic Commerce Provider Directive have taken a safe harbor approach, which is called the notice and takedown approach, where they unanimously assume that if unless and otherwise explicitly pointed out by an aggrieved party, the web host or the e-commerce website in this present scenario is not liable. Unless he gets to his knowledge, he can take it down. Whereas in the United States of America, they take a contravening approach. They state that under Section 230 of Federal Communication Decency Act, that internet service provider or web host or e-commerce website in the present case they're exempt from liability as they do not have any knowledge. And the Digital Millennium Copyright Act provides them to notice and take down approach for only copyright infringement approach. Where in this present scenario, we could see that United States of America does not address the concept of fake reviews when it is posted as an opinionated statement. Moving on with my third point, who can bring a legal action? The concept of locus standi in every country has been differentiated. In India, there are many situations we can see that even the public interest litigation has been taken into consideration. But in the concept of fake reviews, European Union and the United States of America unanimously agree that only the consumers whose economic interests have been violated and competitors who have faced grievous losses can file for legal action. However, in United States of America, Federal Trade Commission which is an independent agency, can suo moto file and proceed with the proceedings, provided they have a reasonable ground that such unfair competition and there exists a fake review being affected for a consumer. Moving on with our empirical findings, we had circulated a questionnaire for around 120 people, and where we found around 80 responses for the same. We had divided our questionnaire into four themes. The first theme was star ratings and detailed review. The questions which were posted to the survey takers were whether a 4-star rating and 5 negative reviews will impact your purchase decision. They agreed that they would purchase the product irrespective of the negative reviews, and they had stated that if a review has 3-star rating, you will purchase the product. They agreed that they still purchase the product. Moving on with our second theme, profile and language used by the reviewer. Here we had posted 2 questions. The question was name or profile of the reviewer determines whether the review is fake or not. And the second question was a review with poor grammatical language is always fake. The survey takers had stated that they agree that the name or profile of the reviewer is always determines whether they were in their purchasing decision. And if a very reputed person, let's say in the present case, an Elon Musk reviews in the present scenario with his Twitter tick mark, it is considered to be a very valuable opinion, and they are influenced by those purchasing decisions. And if there is a poor grammatical language, they're still not worried about such poor grammatical language as long as they're able to understand what the review is. Moving on with our third theme, positive and negative reviews. Here we had posted 2 questions where first question was more positive reviews means more the reviews are fake, and extreme review, which is a positive or a negative review, is always fake. The survey takers stated that they disagree with the statement that more positive reviews means the reviews are fake, and however they agree that extreme reviews is always fake. Moving on with our fourth theme, trustability and practice of review. The research for questions which were posted was whether fake reviews have been a common practice in the Indian market. And product ratings are easier to trust, whether you have witnessed significant variation between product review and an actual product. Here we could see that the survey takers have agreed that fake reviews have been a common practice in the Indian market. And they also agree that product reviews are easier to trust because they are convincing. And they agree that they witness significant variation between the product review and the actual product review. Here we could see that in the fourth theme, though they accept the concept of fake review being prevalent in the market, they're still believing in the system of fake reviews, and they're trusting in the system of fake reviews. To conclude our presentation, I'd be stating digital platforms must work with the consumer protection, consumer affairs, where Department of Consumer Affairs has recently stated that they will bring a framework for addressing the fake reviews. Digital platforms must also be given a fair chance as to represent what are their concerns, since they they confront various difficulties in the current regime, and also a major set of consumers who are prevalent in the market, being from 18 to 25, who are very indulgent in regular purchasing of e-commerce products, must also be taken into consideration to address this concept of fake review. And this committee must also take into consideration this following suggestion: creation of a standard verification and rating system for e-commerce websites. As we saw in our empirical findings, that consumers tend to believe the product ratings and the star ratings in particular. If the framework brings a standardized verification and rating system for our e-commerce website, then such reviews would not be fake and bogus, and such verification would enhance the consumer participation and impact their purchase decision. In the second suggestion we would give is that to loosen rules governing standard in lawsuits against unlawful advertising. We could see that in European Union, Article 4 of Misleading and Comparative Directive, they have allowed using of another person's trademark as long as it does not denigrate or does not take unfair advantage of the trademark or does not present goods as a slavish imitation. So in that case, a trademark can be used in a fair motive to promote a product, and also create flexible channels for both individual and group remedy under consumer law. We could see that the internet platforms for their party review, they keep safe harbor provisions in European Union, and also take notice and down principle into consideration. And the third suggestion would that promoting consumer association, as stated by many laureates, and also in the present scenario, that every individual is not capable of hiring a very high quality lawyer or understanding the legal sense how to face their lawsuits. For consumer associations who take, such as non-governmental associations, organizations in the present case, who indulge in such activities must be promoted and they must be recognized in the present scenario, so that their actions can promote and preserve and protect consumers' interests. With this, I would like to conclude our presentation. Thank you.
Can you also please stop screen sharing? That would be it. Karthik?
Yes, 1 minute.
Right. Thank you. Right. Thank you, Karthik, for the presentation. We'll just be moving on to the third presenter now. Unfair suggestion, an empirical and doctrinal study of recommender algorithms used by e-commerce entity by Pratyanik Chakrabarti and Dr. Prantik Chakrabarti. Please go ahead.
Hello, am I audible and my screen is visible? Hello?
Yes, sir.
It is visible.
Yeah. Thank you, everyone. So, hello, namaskar, everyone. I am Pratyanik Chakraborty. I will be presenting our paper, Unfair Suggestion and Empirical and Doctrinal Study of Recommender System used by e-commerce entities. So before starting our presentation on our paper, let's look into what were the motivation behind our study. So currently, India is witnessing an e-commerce boom, as shown in the graph on the left of the screen. And at the same time, because of this e-commerce boom and this large amount of the large number of e-commerce platforms and millions and millions of options on those e-commerce system or e-commerce platform, they have to channelize those options. To channelize those options, e-commerce entities most often use a thing called recommender system. As shown in this picture on right, that Homer Simpson is buying a drink called Duff, and because of his previous search information, previous search histories, the e-commerce platform is suggesting him to buy a t-shirt by Duff. So that's basically the recommender system. By using the previously used information, previously used browsing information and etc., the e-commerce entities are providing us with their own recommendations. Now, existing body of literature suggests that because of these recommender system, there is a possibility of an existing dark pattern. Dark pattern is defined by various literature as a deceptive, coercive, or any other means of methods or means that steers the decision making of the consumer. It can be any kind of, as Mathur have pointed out, we have mentioned this in our paper, there can be many dark patterns. Further, the relationship between the e-commerce and the consumers is a contractual obligation, is a contractual relationship. And as contract defined under the ICA, under section 10, free consent is one of the cornerstone of that contract. Further, as free consent defined under section 14 of ICA, it should be in absence of coercion, undue influence, misrepresentation, fraud, or mistake. So here is the contractual relationship. But above that, the contractual relationship is not governed by any on paper written contract or any implied contract, as we know. Those are governed by certain e-contracts. Those e-contracts are used to gather information, based on which informations the recommender systems are used. Those e-contracts are click wrap, shrink wrap, browse wrap, any kind of contracts. So to ascertain the fact whether there is a dark pattern in Indian e-commerce ecosystem or not, we have conducted a study, an online empirical study, where we asked our respondent primarily 10 questions. 7 of them were to ascertain where there is a particular existence of dark pattern or not. We asked our respondents whether they were ever asked to make a mandatory account to place their orders, which was the dark pattern of forced enrollment. Then we asked whether they ever saw any insurance, any kind of other allied products attached to their order while checking out, which is sneaking. We asked whether they saw any hidden cost that was attached to the product or not on the e-commerce entities. We asked whether the e-commerce entities created any urgency, like there is this limited period of offer, there is this limited amount of stock. We asked whether there is misdirection or not. Misdirection in means of trick questions, like "maa ki yaad aa rahi hai to maa ke jaisa banaya hua dal kha lo" from any kind of food delivery services. Any kind of confirm shaming, like thousands of people has bought this watch, why you are not buying this watch. Then we asked visual interference by the e-commerce entities, whether there was any visual interference, whether any particular product was given preference over any other product or not. So we had our target e-commerce entities were 9 of the entities which are on the left of on the right of the screen. We gathered information from 247 respondents who are from 22 higher education institutions from North and Central of India. Their age group were between 18 years to 34 years. And we consciously took this age group because as per the available data, the internet penetration is the highest among this age group. So as we got our empirical data, our hypothesis got quite ascertained that there exists a dark pattern. First of all, we got the data that's more than 62% of our respondents were frequent buyers who buys from these platforms more than 1 to 5 times. Further, we got there is a misdirection, misdirections that are there on the e-commerce entities, and Myntra, the niche clothing platform, is one of those big names in that case. Then we got there is a visual interference. One of the biggest e-commerce entity, Amazon, is a prominent name in that case. There is a sure urgency created by those platforms where Amazon and Flipkart's name came again and again in this case. So in this, so because of the discussion, let's ascertain what might be the dark patterns position under the existing Indian contract law. So as we already discussed, one of the basic component of a valid contract under Indian contract law should be where there is a free consent. And as free consent defined, there should be absence of undue influence. Section 16(2) under Section 16(2) of Indian Contract Act, to ascertain there is a there is an undue influence or not, there should be 2 components of undue influence. First, there should be a fiduciary relationship, and there should be an unfair advantage because of that fiduciary relationship. The fiduciary relationship there exists between the consumer and the e-commerce platforms. because the informations by which these recommender systems are used are given to those platforms because those consumers has a confidence in those platforms. So any information that is given in confidence creates a fiduciary relationship, as the existing body of literature says. Further, we have seen that the e-commerce entities has increased their sale by exorbitant amounts. As it's mentioned in the slide only, Amazon's sales increased by 20 to 30% because of this recommender system. So there is an unfair advantage, which is quite prima facie. So we can quite easily conclude thus that there is an undue influence, and the contract of an implied contract of buying a service or good from the e-commerce entity is induced by undue influence. Now, the thing is, dark pattern thrives on information, the information that are gathered. Now, those information are gathered through the e-contracts. Like if we open any e-commerce website, first we will be witnessing a thing coming up, and we have to click either I agree or I do not, and we will be given permission to enter that e-commerce website or not. Now, those e-contracts basically enables the dark pattern, because that makes it possible for the e-commerce entities to gather the information. Now, let's ascertain what's those e-contracts is standing under the current regime of consumer law. So as per our study, as we have conducted our study on the 9 targeted companies, all those e-contracts that are presented by the platforms are standard from contract. And in those standard from contracts are take it or leave it nature of contract. At Tillotson, in his famous Butterworth book, Tillotson Commentary on Contracts, points out that in case of take it or leave it contracts, take it or leave it standard from contracts, because of consumers' economic necessity, there is a little room to negotiate, and in most of the cases, the consumers has to agree with the terms and conditions and covenants. In our own empirical study as well, we asked the respondent, have you ever read the terms and conditions of those platforms or not? Even though those respondents, majority of these respondents were from law schools and national law schools, more importantly, majority of them said that they have never read any of the terms and conditions of those e-commerce entities. Now, in this situation, what is the position of these e-contracts under contract law? The section 246 of the Consumer Protection Act, the newly enacted Consumer Protection Act, gives us a scope for of calling any contract unfair based on its substantive unfairness. Further, there is this case of Rajendra Sharma versus Aeropolis Infrastructure Private Limited from the Punjab Haryana State Consumer Commission, where the Consumer Commission opinion that any standard from contract which are one-sided and biased should be called unfair contracts under 246. In this situation, we are of the opinion that these e-contracts are one-sided and biased. One-sided because these are standard from contract in take it or leave it manner, and biased because these are enabling to these e-contracts are enabling the consumer to witness a undue influenced contract. So these are biased. Now, let's take a step back. If these e-contracts and further the undue the implied contract induced by undue influence are basically taking away the rights of the consumer, then are they standing on the consumer laws a good standing or not? In this situation, we conclude that they are taking away the rights of consumers. And in this scenario, we have suggested few things. First of all, because to prove that the recommender systems and dark patterns are taking away the rights of the consumers, the courts have to first declare the e-contracts invalid, then the implied contract as undue influenced contract, then have to give the consumer remedy, which might not be possible for a consumer court, which has a summary judgment proceeding. For that, we suggested that there should be a recognition of unfair trade practice under Consumer Protection Act. Further, we urge the Central Consumer Protection Authority to initiate proceeding on in the competent courts against the use of those dark patterns. And we have given few managerial suggestions as well to the e-commerce entities that they should use these recommended systems diligently and responsibly. And given the ESG and business sustainability issue in hand, they should promote the fair bargaining power of consumers. So it was our presentation. We conducted this presentation, and extremely thank you for to everyone for their attention. For any information, you can reach out to us. Thank you.
Thank you for the presentation. We shall just be moving on to the fourth presentation now, titled Trap of Dark Pattern to the Middle Class versus Trap of Digital Learning to the Poor, the Silent Coercive Tools to Exploit Consumer Choice by Prasanna B. If you may, go ahead.
Yes, I'm there, and just confirm whether I'm audible and visible, and my slide is visible or not.
You are.
Yeah, thank you. So, respected dignitaries and participants, a very good afternoon to one and all. I'm extremely delighted to take this opportunity to present my paper title, Trap of Dark Pattern to the Middle Class versus the Trap of Digital Learning to the Poor. It's a silent coercive tool to exploit consumer choice. To give a brief insight of my presentation, I've divided my research analysis into two segments, that is the trap for the middle class and the poor. So why did I choose to address the poor consumer? Is that still over 25% of the people in India are illiterate, and over 75 million people live with income less than 5,000 per month. And to say illiteracy and economic inability are the predominant factors for consumer exploitation. And to say that these are poor are the most vulnerable class of society, and they can be easily exploited. And here we can see that out of one in every four Indians faces discrimination in a hospital on the grounds of religion and caste. Still now, this practice goes on, and gender prejudice is not an exception to women as a consumer. The physiology of women is very different of that of men, and most of the drugs which are manufactured by the healthcare industries, the big giants, are mostly the men-oriented drugs, and this has to be kept in the north. And so let me talk a little bit about what has happened during the COVID pandemic and how consumers and the poor are being exploited. And 96% of the migrant workers did not receive any kind of rations in their previous systems. And this was clear violation of consumer rights. During this period, we have seen enormous growth of black markets at its peak, and social media have been the medium to medium as for consuming the black markets. To touch upon this healthcare, the drugs marketed during these times, remdesivir medicine, which was costing a few thousand, and it went up to around 82,000 medicine, and gas, similar as that, oxygen gas cylinders went up to lakhs of rupees during this period, and how could we expect that poor can afford these kind of things, and so most of the lives are lost in these things. And these are artificials or a shortage of made by the retailers and not the shortage that were demanded by the people. All these drugs price increased drastically during this period, and the price seems exceptionally high as no poor out of 1.5 billion with a income less than 2,500 500 rupees per month can afford such a cost of healthcare. So the unattainable dreams of participating in the digital world in the poor class has been like, to give an example, the India government of India conducted vaccine drives across India with this digital platform of COVID, and without understanding that the most of to precisely say that more people are in India, across India, several number of millions of people were did not have the access to internet at this point of time. And let me talk about a little bit about the digital learning, and to iterate what I mean say is that anything forced to a consumer is a violation. Over 60% of the students did not receive education due to the reason that they didn't have smartphones in the earlier phase of COVID pandemic. And everyone in the family needed a smartphone at this time, and everyone was forced to get a smartphone at this point of time, which is again a consumer violation. And the more pathetically in the education sector, they were the educational institution demanded fees that tuition fees at this point of time. So the right to health and education should be considered under the consumer protection laws. And to having said that, 4% of every income tax that is being collected by the citizen goes, as I said, to healthcare and education. Now talking about the era of e-commerce. So the modern marketing platforms. So what are the problems that we face in these modern platforms? Is that one of the major problem that we face are these are unorganized. When I mean to say unorganized sale, social media plays a prominent role in unorganized sector sale. 55% of sale happens through social media over apart from e-commerce entities. E-commerce rules state that every e-commerce entity must be registered under Companies Act, but there is no such a thing that happens in a social media platform, and there is no registration that is mandatory for an e-commerce entity. Sorry, for an entity in a social media sale. This creates a more problem to the seller, to the buyer. Seller gets the money for the product that he posts in the social media, and he might not deliver it to you. And when you try to reach out to them, you find that there is no such a account existing, and that's where we have to have an exclusive provisions under consumer e-commerce rule. So let me talk about a little bit of fake reviews, ads, and products. These are dealt with the presenter before me, but I'll try to little bit brief about it. Over 70 to 80% of our consumer choice is based on customer review. All right, and no direct interaction. This is because there is no direct interaction between the seller and the buyer, and obviously, and there are 4% of every customer review that are posted in major platforms such as Amazon, Facebook, sorry, Flickrs, and so on. These are fake reviews, and government has to come up with some kind of authentication over these fake reviews. 38% of people who receive products from these big giants of e-commerce are fake, fake products or either counterfeits. And talking about fake ads, Google says that they are detecting 5,000 plus fake ads every single minute, and and these last not more than 5 minutes, and then disappears. So these are the things that we face in the model error. And I will talk about this trap of a dark patterns to the middle class. Middle class society is the prey of this trap. The reason behind is that the rational pattern of the middle class oscillates between the desire and needs. Um, Let me give a little bit of what is this dark patterns are. Um, you must have come across these notifications in your mobile phone. Let me read a few. Uh, hey, you must be tired, ordering something delicious. And something like, hey, yes, pizza, Mrs. You, order it now. Something like these kind of messages pops up every now and then. And a dark patterns of profit gain strategies by companies having um, playing role to manipulate consumer choices. Now the question is, how do these companies know that at this point of time I'm hungry, or at this point of time I want this kind of uh, food, or maybe the product, and this is where these dark patterns comes into play. A dark these interfaces detect data that are stored in your mobiles and that are sold to different entities for manipulating consumer choices. Over 11% of online websites use dark patterns. Uh, but these are pop-up messages like item added to your cart, flash sales, free trial, top sold items, and so on and so forth. So what is these uh, dark patterns? Uh, what are the problems in dark patterns? The major factor is these infringes our data privacy. Every little data that is stored in your mobile from your Google search, what you liked it on Instagram or Facebook, or what you have shared in WhatsApp, what you have in your cars or from Amazon, Facebook, your subscription on Netflix, and so on and so forth. These are your data of your interest, and these are being taken from your mobile and sold it to some entities. These are entities of e-commerce, and they use these data to manipulate you on taking the decision that you might not desire to do. So the personal data bill has to include the terminology of psychological manipulation under the principal definition of harm. But unfortunately, yesterday, the new data protection bill, which was kept for public opinion, did not uh, find to have fulfilled the demand of the provision. So I have few suggestions to make in this point of time regarding health and education. Should be included in the comprehensive definition of consumer service. Although I personally do not agree with the ideology of morality. Ideological morality of a welfare state like India uh, to uh, protect healthcare and education and the consumer protection. Rather to provide these are fundamental rights. Education and health should be a fundamental right, and that has to be provided by the state because we are tax-paying citizens and we are bound to have it. Uh, so now it is a time that we have to have e-course when we talk about e-learning, we talk about e-commerce, and it is time that we should shift to e-course that are In the view of the Chief Justice of India, T. Chandrachud, said the same, and that was like the e-courts are the future of judiciary, and consumers have to, and in a place that the e-commerce rule and says that a consumer has to complain within 44 hours, and the complaint will be redressed in 1 month period of time, which is not that we want at this point of time. And dark patterns, and when we talk about dark patterns, it has to be banned in India. Data protection law should include psychological manipulation as a fundamental definition of under harm. And lastly, the fallback liability has to be included in the liability provisions of the consumer protection laws. And to conclude that, I want to say that anything that is forced on the consumer or anything that is manipulative to the consumer is a violation of consumer protection. Thank you.
Could you please stop the screen sharing if possible?
Yes.
Thank you. Right. Thank you. Thank you for the presentation. It doesn't appear that I've received any questions as of yet, although we can wait a little bit more if anyone has any questions. Otherwise, we can move on with the chairpersons and their suggestion and their feedback and their address. I believe we have one question from Sonia Man, which is, can we read dark patterns under CPA 2019? Could you please elaborate which participant is this targeted towards?
Certainly, if I am allowed to reply to this query. Yeah, so to read dark pattern under COPRA, the newly elected COPRA, we first have to prove the e-contract that we showed in our presentation in our research as well, which is gathering the information as unfair contract. And which is basically the e-contract is basically enabling the dark pattern, and then in this case the dark pattern will be read into. Otherwise, another thing that can be done is basically an Central Consumer Protection Authority's class action initiative, where there is a violation of consumer rights. In these two cases, I guess dark pattern can be read into, but there is no explicit provision that says that dark pattern or any dark pattern like thing is there in the act as of now. And our suggestion was on the same line that there should be a recognition of dark pattern and recommender system under the COPRA.
Thank you for the answer, Mr. Pratyanik. I believe if we have no other questions, we can move on to the chairperson's address.
If I could just quickly come in and, add substance to the answer.
Right.
So absolutely, this makes sense that all of you have come to the realization or perhaps the quick conclusion that dark patterns have not been spoken of in the Consumer Protection Act. But very clearly, they do subtly hint at those provisions in order to secure consumer protection in a better way under the 2019 legislation. You spoke about unfair contracts, but you did not go to unfair trade practices. Under clause 9 of subsection 47, you see that it says that you can't disclose information which has been given in confidence. If you read that with 247(1)(f), it says that you can't make feelers to the consumers about the necessity of something or the attributes of something which is not clearly correct. So, I mean, I agree that, dark patterns have not been specifically spoken of, but we can't dismiss the Consumer Protection Act by saying that, dark patterns have not been considered at all. So this is something.
If I may just add a point to that, in our paper, we have mentioned the point that there is a provision where in the under unfair trade practice that says so at you suggested, but there was a mention of any third party. Now we have mentioned that if an e-commerce entity is analyzing that data or anything, doing anything else, anything with that data with a third party contractor or outsourcing their data analyzation to anyone else, in that case, we can hold them liable. But in a scenario where a huge multinational corporation like Amazon has their own data analysis team, they are essentially not sharing that to anyone else. So this brings us to a tricky point where there will be ambiguity. And given the parents patriot situation of consumer under consumer law, there should not be any ambiguity and there should be purposive interpretation of law in favor of the consumer. And so I guess it would be beneficial for the consumer to directly recognize dark pattern under the law.
Like I said, this is a beneficial legislation, so ambiguity is always cleared in favor of the consumer. So if we don't have clause 9 coming into help, we'll have 47, maybe, clause 1F, which says that you can't highlight very disproportionately the need or the requirement of a product. This equally falls, like they don't specifically mention this of the seller or the manufacturer. This can equally, barge in like the intermediary as well. So that's something which I wanted to add. And with Anita's permission, if I could just generally go first.
Yeah, definitely, certainly.
So
yeah.
I feel that, when Ruth was mentioning, when she was sort of going with the project, she mentioned the need of a specific watchdog. I really don't find much substance to that argument, given that we already have the CCPA and the general powers of the CCPA. The CCPA is adept at handling those, sort of considerations. The second was when Pratyanik, I mean, it's Pratyanik, right? Yes, Pratyanik. So I sort of addressed the idea which I wanted to mention with regard to you. Then we had Karthik mentioning that locus standi must be loosened slightly. I mean, I understand that the DCDRC perhaps may not be the best suited, adjudicatory body to relax locus standi, but we do have the CCPA, which does not, sort of fall under the trap of locus standi. So, I mean, that's something which you can, sort of figure out into your paper if you develop that further. And then we also had, of course, dark pattern I already spoke of. And these are some general feedback which I wanted to give. And of course, Anita is the more expert on this issue. She can just...
No, not certainly, but yes. To go with the permission of the moderators, can we go ahead?
Yes, ma'am, certainly.
Yeah. Okay, so how much time do we have?
So we are currently at 3:25. We will have approximately half an hour left because the valedictory starts at 4 p.m.
Yeah, before 3:55 we have to wind up, right? Yeah.
Yes.
Yeah, to begin with, I think firstly, congratulations to all the presenters over here. I think thank you for all coming here. All your efforts have been really acknowledged and appreciated. So congratulations to all the presenters. Coming to the way the presenters mainly, went with, I think first we had Professor Ruth from NLUJ. Yeah, where ma'am mainly had addressed on an avenue of combat to fake reviews on e-commerce platforms, where mainly ma'am told about the types of e-commerce, the attributes of the purchasing decisions, where she mainly mentioned about the the difference or the distinctions between the how a online user feedback is something different from an online reviewer, a differentiation or the definition between social influencer, and also in that she went into detail regarding the micro and the the micro and the make influencers and how exactly they are being mainly determined. But another thing which I want to mainly come to the point where, especially with regard to your suggestions, I hope Professor Ruth is here, where you said about the establishment of a watchdog. Then, as rightly pointed out by Professor Avantik, when we already have a CCPA, right, we already have a Central Protection Authority which has already been established in the new regime, then why do we need another watchdog which would mainly when we already have, because multiple bodies or multiple monitoring bodies would have a lot of confusion as to what exactly is their role, what exactly is their functioning, what exactly is their powers, right? So already when there is a CCP there, when they're already looking into unfair trade practice, they're looking into unfair contracts, they're looking into misleading advertisements, they're looking into e-commerce platforms, they're looking into many other regimes which is coming under the one overarching legislation called as CPA 2019. But why do you mainly suggest it? Because your first suggestion was mainly to establish a watchdog. Was it the mainly, are you asking about the enforcement? Are you challenging the enforcement of how exactly will it be effectively and enforced, efficiently done by CCP? Is that what you meant? Or because as you mentioned in your suggestion, it was mainly asking for establishment of watchdog. If Professor Ruth is here, you are free to answer us. Professor Ruth? Avinash, just check if ma'am is here.
I don't think Professor Ruth is here.
Okay, fine, no problem. So just going forward, ma'am also, like, Professor Ruth mainly mentioned about the explicit online platform or a portal. I feel when we already have a platform, especially a portal called as gamma.gov.in, which is mainly done by a Ministry of Consumer Affairs, which is mainly looking into the misleading advertisements. Why can't the misleading advertisement portal itself take care of the fake advertisements or fake reviews, or mainly encountering or spotting whether it's a fake or a genuine reviews? Can't we do that? Why do we need another platform or a portal when it needs a lot of time, money, and resources, right? We already have that. So why do we mainly want another one when we already have an existing? Yes, it can be, it is already included. The Gamma portal is already taking care of misleading, where yes, the Ministry of Consumer Affairs will be also looking into the fake reviews, where it is, no doubt, I do agree that it is difficult to spot the fake ones and the genuine ones, but yes, it can be done through the e-commerce platforms, where they already have been given under CPA, where they have 10 lakhs to 50 lakhs of penalty provisions, which is imposed on the e-commerce platforms also. Ma'am also disclosed, gave a suggestions framework for disclosure agreements and impose of a hefty fine. I feel that it's already there in the CP Act. If you compare it with the old regime of 1986, if you compare the penalty provisions that are much more higher, much more stringent, and much more heavier than the old 3-decade-old legislation. So I think it could have been some much more better suggestions could have been coming forth. Coming to the second, we also had from Abhinav, Ramesh, and Karthik, where it was on trusting a review, tricky issues in consumer protection. Yes, they also spoke about the engagements. They talk about the empirical data as well as the doctrinal, where they mainly came up with the comparative study with EU and the empirical findings, where they mainly had 4 aspects which they mainly based their findings on the star ratings, profits and earnings, positive and negative ratings, and the trustability and the practice of reviews. So no doubt we do appreciate the reviews, or we can say the empirical study which was being done, and also it was mainly highlighted on e-contracts, which mainly enable dark patterns. Here the suggestions which mainly came up was mainly creating a standard and a vertical and rating system for e-platforms to loosen that. I would definitely agree with Professor Avantik, which he mentioned that why do you want to, is Mr. Karthik here? Avinash, is Mr. Karthik here? Because it makes no sense if I'm talking and if there's no one to respond.
I see him there.
Yeah, I think they're there. Let me just double check.
Yeah, because if we could get answer right now, I'm not able to
unmute, he says. Yeah.
Right. 1 second. I'll just make sure that's fine. You should have gotten a prompt by now. Karthik, I think you should have gotten a prompt.
Hello, yes, ma'am. Am I audible?
Yeah. Could you elaborate, because I and Avantik were on the same page when you said about the suggestion, the second suggestion which you mainly addressed us.
With respect to advertising,
to loosen the rules regarding the standard in the lawsuits, and mainly talking about your suggestions. We are talking about your suggestions at the end, which you mainly mentioned.
Yes, ma'am. Ma'am, the first suggestion was creating a standard of rating system, and second suggestion was loosening with respect to advertising guidelines. And
See, already
comparative
just a second. When you say advertising rules, can you be very specific? Because we already have ASCII, we have self-regulation.
Very specific was with respect to usage of trademarks.
Usage of trademark.
Yes, ma'am. In Article 4 of Misleading and Comparative Directive, which we had stated in our comparative analysis.
Are you speaking of European Union one, or are you speaking about the European Union one?
European Union one. Yes.
Okay.
We had stated about when a trademark can be used. That scenario is not being indulged in the Indian perspective.
No, if you look at the unfair trade practices definition under, again, I just keep going back to 2 subsection 47. There is a provision which says that you shouldn't use the name of your competitor as in a disparaging way, which I can, sort of corollarily say that in a comparative space, you can use the name provided you don't disparage. So the EU principles again come here also under consumer protection.
Sir, I beg to differ because on the fact that there is no explicit content here, because they are stating about denigrate or like very specifically they state about discredit or denigrate trademark in this. It's only subject to interpretation in Indian scenario, whereas in the European.
If you corroborate this with like what ma'am was saying, the ASCII rules, Advertising Standards Council of India, you will find that both of them are on the same page. So at the Advertising Standards Council of India, although it is self-regulation, it has now come up with digital disclosure under 2021 guidelines. So all of them, it firstly puts up a obligation upon you that if you are advertising something, you have to disclose. And secondly, under the conventional ASCII rules, you'll also have to mention, like when you use comparative advertising in a space, you can sort of puff up your product. You can say that your product is the best, but you can never in the same sentence say that that product is really bad. Like that is under the ASCII rules again. I understand that, you perhaps want to wear the lawyer's hat and say that it's not specifically mentioned, etc., etc. But if you corroborate the different spaces of law, you will find that there's one converging point, which is very similar to the EU standard.
Second aspect of our suggestion in the second point was using of notice and takedown principle, which is not visible in any of the laws, consumer protection rules, the act or the rules. The notice and takedown primarily helps the website hosts, the e-commerce website in this present scenario. Upon when they come to knowledge, they can remove that fake reviews in the present scenario. So thereby, this misleading advertisement cannot be put forth in the e-commerce websites. That was our second suggestion also.
The same standard, is used in the MySpace judgment in the Delhi High Court. So we also follow the same DMCA standard of takedown, but conventionally it is only used in the copyright case, which you correctly.
Copyright. Same problem is in the US also, sir.
Right.
Thank you for your suggestions. I'll duly take it.
Yeah. Going forward, we also had another third speaker, the presenters who mainly addressed us on unfair suggestions, an empirical and doctrinal study of algorithm used by the e-commerce entity. Here, it was mainly presented by Mr. Chakravarti. So here, no doubt, this paper was very much comprehensively presented, which mainly spoke about the contractual relations, the e-surveys done, the collection of data. They also very finely portrayed us about the sample size of 247 responses, the age criteria, the responses received by the 22 law schools through the student body, as well as they mainly mentioned about the case laws on Rajendra Sharma, which mainly talked about the state commission's judgments. Coming to their suggestions, where mainly they said that the recognition of dark patterns as unfair trade practice. So here I would again defer to the point that saying that no doubt, as Professor Avantik already mentioned before we started with this discussion, saying that it may not be in a particular nomenclature as dark pattern, but it is already mentioned in our CP 2019 under unfair trade practice. Yes, I do agree that you may say that it is not comprehensive, very, the nomenclature is not as dark patterns, but it is inclusive in our definition of unfair trade practice, as well as already you said about one more suggestion. Yeah, that is your second suggestion, which you already mentioned regarding the policy decisions, you mentioned about the policy decision. I'm talking about the second point, which you mentioned was initiate proceedings against user of dark patterns by CCPA, which I agree that they are already in the role to play a role to play for monitoring. They have the powers, they have the functions, they have suo motu powers. I would like to again bring to your notice that they have suo motu powers. That means that they don't have to wait for any complaints. They themselves can take action against any dark patterns, any sort of unfair trade practice which is happening, which is mainly determined under the CP Act. They have the suo motu powers. They don't have to wait for any sort of complaints. So in fact, I would like to say that the suo motu powers can be like prevention better than cure. They don't have to wait for the damage to be done for the consumer. They themselves can take action, right? So I would really have, we both are not that convinced with the suggestion when you talked about that to recognize dark patterns as UTP, as well as second, that is initiate proceedings against the dark patterns by CCPA, because they are already into that. They already have that role to play. Yes, I would definitely agree that if your question would be that how, if you're challenging or if you are mainly questioning about the how they would enforce, yes, that we would say that it is a bit contemporary issue, because we need to see the effectiveness. We have to see the enforcement efficiently, whether they are doing it efficiently. Yeah, that we can definitely agree. But talking about whether they have that role or no, yes, they do definitely have that power to do so. Avantik, would you like to add something to this?
No, I absolutely. So that is the correct answer. So when CCPA has suo motu powers, and it has a lot of powers, because of which, some of the suggestions fall flat, because there is ambiguity in the wording of the law, and that ambiguity is in favor of the powers of CCPA because it is meant to enforce consumer welfare. Like, so in that instance, when ma'am is mentioning that, why would CCPA sort of, take the matter to the DCDRC or any other adjudicatory body? I mean, they would only take it when there is a matter of compensation which comes in for the consumer who has been wronged. And if you look at it, you don't have to invoke the CCPA's sort of initiation or the enthusiasm in invoking compensation, because under a dark pattern, it would be a case of product liability also. It could be like the harm which has been caused because of the initiation of dark pattern. If you can establish harm under 222 and read it with 234 of product liability, I can go for a product liability claim. The CCPA, is most important when it is preemptively ensuring consumer welfare by trying to set in guidelines, which is within its mandate. Of course, what ma'am mentions is absolutely correct. How will the CCPA mandate sort of enforce these guidelines? It has power under section 22 to sort of penalize, and all of that is there. But, forming consensus on the enforcement of such guidelines would be a tricky issue, because most of these platforms have become quasi-sovereign. They are governments in their own space. So that is.
Yeah. So moving to the last one, it was on trap of dark patterns to the middle class versus trap of the digital learning to the poor, the silent coercive tools to exploit consumer class. So here it was mainly presented by Mr. Prasanna, and mainly it was mainly highlighted about the statistics of exploitation of the poor consumers with regard to different scenarios, like women with regard to the e-commerce platforms. The era of e-commerce was being mainly showcased, as well as how the tackling of the future problems in the world of digital era, and where the presenter also mainly discussed about the trap of different dark patterns, such as add items to the cart. It might be flash sale, it might be top seller, or it might be the free trial which has been given by the e-commerce platforms. And also the presenter mainly talked about the data privacy rights also. Here the presenter mainly came up with certain suggestions, with this mainly focusing on e-learning. E-learning, when I say e-learning or e-consumer or consumer education or consumer awareness, it's already a very important consumer basic right, where like, for example, it might be Jago Grahak Jago, where it is a campaign which is run by the ministry itself to ensure that the consumers are aware of their rights, or you can say mainly to ensure that they are well informed about their rights, so that they can mainly address any of the issues when it comes to unfair trade practice. E-courts, I think right now the CPA has already given a power where they can also online filing has been enabled, right? Initially, if you see the old act, there was no any terminology, or there was no any sort of proceedings which could be done online. But right now, all these proceedings can be filed, especially with regard to, I'm talking about only Consumer Protection Act 2019, right? We are, because here it is a consumer perspective. Yes, we do have e-filing at the 2019 regime also. Coming to the third suggestion, you told about the healthcare. I did not understand the context, but yes, if you are there here, you can definitely revert back. Dark patterns, you said that they should be, privacy laws should ban the dark patterns, right? And the fifth suggestion was the fallback liability, where you said about the e-commerce rule should exclusively include liability where it is already there in the product and service products liability, which is chapter 6, right, under the new regime. And data protection is also there. It's already there, where they're talking about, you mentioned about the psychological manipulation under the definition of harm. So if you are here, Mr. Prasanna, are you here? If you could elaborate, or if you could substantiate more, or if you have anything else to answer, because of the constraints of time, few of the presenter may not be able to substantiate your thoughts. But if you want to answer here, you can definitely do that.
So when I talk about this healthcare, I was precisely talking what was happening during the COVID pandemic and how we should tackle about that. So it was in that context, and I've in my paper I've substantially given everything that has to be done. And obviously, and you talked about fallback liability also on. And fixation of fallback liability is the main concern that I wanted to point out. Fixation, in the sense, there are three parties involved: the buyer, seller, and the e-commerce entity, right? Now, how to fix the liability of e-commerce entity and the retailers and the e-commerce entity? And there are a little bit of issues, and if there is a defective, if there is a defective product which has been sold by the retailer, and why will the entity be liable for it? And if something like the entity gets the product from the retailer and fail to deliver it, and why will the retailer be held responsible for it? And these are the things that has to be exclusively dealt with.
Okay, thank you so much. Amantik, you have anything to say?
No, I think, sort of you covered everything well. And, just as a closing remark, I feel most of you have done really well. In, presentation, I see that there's some second and third year students. We would skip our vivas so that, we wouldn't have to speak in front of people. And it's fantastic that, you have presented so well before us. And, you have knowledge you've also read, and the idea that you are able to defend the questions and also defend the statements and answer the questions which you're posing is something which just speaks to your efforts. So congratulations, a big congratulations on that.
All the best for all the presenters. Very good luck, and over to the moderators.
Certainly, ma'am. Greetings, everyone. After an extensive and lucid discussions on consumer law pertaining to consumer protection from fake reviews on e-commerce portals and other dark patterns, we find ourselves at the end of this session. On behalf of the entire law school community, the Chair for Consumer Law and Practice with the Ministry of Consumer Affairs, as well as the participants, I would like to thank Dr. Anita Patil and Dr. Professor Tamta again for providing us with such insight into this unique field of consumer law by engaging in a lucid discussion with the participants. We are grateful to have had your presence here in this conference, as the information and understanding of consumer law that has been revealed today could not have been made more accessible for the lawyer and the layman alike. I would also like to thank the participants for providing us with such insightful conversations and such information into their respective topics, and for presenting in such a beautiful manner and for sticking to the time limit. I would also finally be thanking all the listeners for joining in, and we look forward to seeing all of you, everyone, at the valedictory ceremony at 4 p.m.